So I have to tell you, I usually don't need one of these microphones. It's only for the recording that I'll use it tonight. Good evening, ladies and gentlemen, and thank you for inviting me to speak to you tonight about the social host law. It really is a privilege to be here. Again, my name is Anthony Curti. I'm an assistant district attorney with the Orange County DA's office. I've served there as an assistant for 4.5 years, and in addition to my duties prosecuting cases, being a more traditional, I guess you could say, ADA, I'm also now a part of the Community Affairs Bureau that my office has established. And so it's really under those guidelines that I'm here to speak with you tonight. So what I'd like to do is go over some of the history first of the social host law, really the lack of social host law in Orange County, and then we can get into the specific statute, the specific law, what I believe it is intended to do, how it will be enforced, and what the penalties will be for violating it, and then I welcome any questions that the group might have. So let's do that. So Orange County was really only one of few counties in the surrounding area that previously did not have a social host law. Now, of course, it's illegal under New York state law to provide someone under the age of 21 with alcohol, and that continues to be the case. I mean, they could be charged with things such as unlawfully dealing with a child or endangering the welfare of a child, and the social host law doesn't in any way compromise those statutes. It doesn't replace them. It really just supplements that law. Where the gap was, though, is that it was not previously illegal for someone, an adult, someone over the age of 18, to be aware that someone was consuming alcohol in their home or on the premises that they controlled, and they didn't do anything about it. And that's where the social host law really comes in. So under the social host law, what happens is that anyone over the age of 18 is now charged with the responsibility that if they're aware someone under the drinking age, under the age of 21, is consuming alcohol on their premises or on an area where they're controlling, somewhere where they have authority, that they have a duty now to do something. So what the social host law says, and I actually will read it, I think that's probably the best way to make you familiar with the language, and then we can kind of break it down into what I believe it means. But it says it shall be unlawful for any person 18 years of age or older, and that really is important because the statute, it has determined that to be even potentially charged under this statute, you must be 18 years of age or older, and they own, rent, or otherwise control premises, and they knowingly allow the consumption of alcohol by someone under the age of 21 on those premises and fail to take reasonable steps to prevent that. Now, the law actually defines what knowingly means, because remember, it has to be a knowing act. It can't be something that they weren't aware of. And it says knowingly shall mean that they are aware of, which means, of course, they actually know about it, or they have reason to be aware of the consumption of alcohol by a minor. So what I believe that to mean is that it's not enough to kind of have blind eyes and deaf ears. You can't allow this to happen and say, oh, I didn't want to know about it. That's not okay. If we can show that they had reason to know that this was happening, they could be charged under the statute, just the same as someone that is in the same room, say, as the underage child consuming alcohol. So that's the first part of the statute, that they must knowingly know that this is happening. And then they have to fail to take reasonable corrective action upon learning about it. And the statute actually gives us some guidance as to what that means. And it says that it's limited to, it includes, but is not limited to, making a prompt demand that such minor either forfeit the alcohol, give up the alcohol, or that the alcohol is refrained from being continued to be consumed. So they have to either give it back or at least say that they're not going to consume it. So that's the first step that the person over 18 is charged with doing. Now, if such minor does not comply with that request, if either they straight out just say, I'm not going to do it, I'm going to keep drinking, or if they agree to it but then continue to drink after the person leaves, then that person, the 18-year-old person, has a duty to either promptly report that consumption to a parent, to a law enforcement officer, or to someone that has greater authority over that minor than they do. So to me, typically what that would mean is their parent, perhaps their guardian, someone that has more control over them than the person whose home that they are in has over them. So that's essentially the statute in a nutshell, is that they must, if they're 18 years of age or older, they must knowingly prevent this underage drinking from happening on their premises. Now, it also says that the provisions of this shall not apply to the consumption of alcohol or alcoholic beverages by a minor whose parent or guardian is present and has expressly permitted such consumption. And that's actually not a new theory of the law. That's always been the case, where a parent is allowed to serve their own child, alcohol, even if they are not at the legal drinking age, so long as that person is either there with the child or has expressly given that consent. So that does not in any way affect that area of the law. This is for an 18-year-old person who is not the parent or guardian of the person consuming the alcohol. It also says that the use and consumption of alcohol during a religious ceremony, communion wine at Mass or something like that, obviously is not controlled by this statute. That is still allowed. Premises, which might seem kind of self-explanatory. Premises, it's the place where you are, right? Well, the statute actually defines what premises means, and it says that it's any home, apartment, condominium, cooperative unit, or other dwelling unit of any kind, and public or private property, including yards and open areas adjacent thereto. Now, obviously, as an ADA, my job is to enforce the law along with the police departments, obviously, but we don't interpret the law. That's the job of the court. My interpretation of this, if I was asked what it is things like public parks, pavilions. Although that's not owned by the 18-year-old or more, if they're hosting a party there, a barbecue, a birthday party, they have that same duty as if they were hosting that party within their home. They're not allowed to have a minor consume alcohol at something that they're hosting at one of these public venues, public areas. Minor, obviously, for this statute is anyone that's under the age of 21. That's the legal drinking age, so that's what a minor means under this statute. Now, the violations, the penalties for violation of the statute are also enumerated. For a first offense, failure to comply with the statute is a violation. So now our law is basically broken up into three categories of offenses. Violations being the lowest level of offense, the next step up being a misdemeanor, which of course is a crime, and then the highest level of offense being a felony. So this statute enumerates that a violation of the statute for the first time would be construed as a violation, not as a crime, and it's punishable by a fine of $500. That's not a fine of up to $500, that's a fine of $500. And it says that the court shall fine the person that's convicted by either a plea of guilty or after trial to $500. So the court doesn't have any discretion to lower that, to change it in any way. It is a $500 fine. And I think more importantly, perhaps even than the fine, is that with that first time conviction, the person must also complete an alcohol awareness program and or community service not to exceed 30 hours. Now, really the reason for this statute is twofold. We want to make sure that our children are safe and are not consuming alcohol before they legally can do so. We also want to make sure that parents understand that this is not something that they can do and the reasons why they cannot do it. So I think that educational component of a first-time offense is really just as important, if not more important, than the monetary fine that they would face. Now, the statute doesn't require that they attend any particular program, and I don't think that it would ever be construed that way. I think it has to be obviously something that is reputable and that serves the purpose of the statute, but it leaves some room for organizations like us, like ADAC, to develop programs that would really kind of fit the need that is now being created by the statute. So that's the violation of the statute for the first time. A second offense, a second conviction, shall be treated as a misdemeanor. It's a crime, so it's a criminal conviction. It would go on their criminal record as a criminal conviction. So if they were to apply for a job and were asked the question, have you ever been convicted of a crime? They would have to answer yes to that question. It would be punishable by a fine of $1,000 and a term of imprisonment not to exceed 1 year in the Orange County Jail or some combination of the two. So the court would be free at that point to sentence the person to anything up to a $1,000 fine and or anything up to 1 year in the Orange County Jail. And again, obviously, that would be a misdemeanor conviction, so that would stay on their record. And perhaps I was remiss to mention that a violation by operation of law after a period of time is wiped away from the person's criminal record. It's not a conviction, so it's wiped away. A misdemeanor conviction obviously does not carry that same benefit. That would be a lifelong conviction on the record. And just as a note, any fines that are collected under this statute are specially designated to go into an account designated by the Commissioner of Finance. Now, the law has been passed unanimously, as I'm sure you may have heard, by the Orange County Legislature. It's also been signed by County Executive Steve Newhouse. So it is law. It's good law. It hasn't yet been effective yet. There are some steps that still need to be taken behind the scenes to get the law officially on the books, but it's been passed. It's just should probably be about a few more weeks or so before the law is something that can be charged and can be operable. So that's the statute in a nutshell. Are there any questions at this point about anything that I may have mentioned so far? Yes, ma'am.
One of the questions somebody wanted me to ask you was, say there's a party and there's underage people drinking. They sleep at the house, the next day they go home, they get in an accident on the way home after they've slept off, I guess would be the right term. Is that family still responsible?
Well, under the social host law, as a prosecutor, I would have to prove that the adult, the person that owns the house, or at least was overseeing the house, knew that the underage person was consuming the alcohol. If I can't prove that, then I wouldn't be able to meet the elements of the statute. If what you're asking, though, is if there's a later crime as a result of that underage drinking, it would really all depend on the facts of the case. And I know that probably seems kind of like a Weasley lawyer thing to say, but it really is true. This all goes, case by case. So it would depend what the proof is in that particular instance. There may be liability. It may not be criminal liability. It could be potentially civil liability, which is not something my office would handle, but the family could, potentially at least sue the adult who allowed their child to drink alcohol. So it would really depend if that answers your question.
And is the law enforcement going to be more proactive with this, say with this parties coming during the summer and you get a lot of complaints about the noise? Is there going to be some type of information given by the law enforcement in regards to having parties where they know people are consuming alcohol, et cetera?
I wouldn't venture to speak for any of the police departments, but I can tell you, during my time as an ADA, I've worked with almost every department in this county, and I think they're all very fine police departments. I'm sure once the law is official and is operable, and they're aware of this, that they will be doing, their part to educate people to its existence, what they can and cannot do under the law. I would suspect, and this is just from my experience, that if an officer were to respond to a house party and see something like this going on, I mean, that person may be charged, but I think in addition to charging them, they would also explain why they're not allowed to do what they're doing. So it's brand new. I mean, it's brand new in this county. It's not new, obviously, overall. So there's going to be a learning curve. There's going to take some education of the public before they're aware of exactly what this statute is, what it does, and what it prohibits. And frankly, that's why I'm here tonight, is hopefully to start that ball rolling, getting people to know what this is all about. So, it will take some time, but I'm sure that we will, pretty quickly be able to accomplish that. Thank you for your questions. Yes, sir.
I'm just interested in scenarios where, say, the parents are away for the weekend, or even the parents went on a vacation for a couple of weeks and left the house in charge of 18 and 19-year-olds. Can they claim, I didn't know what was going on, or is the law apply to them as well? Because they should.
I would say yes, that it would apply to them as well. I mean, obviously, again, it's going to be a facts and circumstances type of thing. But if homeowner specifically gives their 19-year-old son, permission to control the house and to control what's going on there, and he or she, then allows an underage child to drink within that premise, I would tend to think yes, that they could be charged under the statute, just the same as the homeowner, him or herself, could be. Yeah. Yes, ma'am.
So if my kid was underage and they were at a party and they came back home and said there was underage drinking going on, as a parent, and after the fact, what would happen? And could I go to law enforcement and you would still charge?
Yeah, I mean, obviously, the best evidence can always be collected while the thing is happening or shortly thereafter. But as as a parent, as a citizen, you would have absolute right to report what you believe has happened against the law to the police department, and then the police department would be tasked with doing their investigation and seeing what they can discover. But I want to make very clear that there's no it doesn't have to be immediately reported. Of course, there are things called statutes of limitations, which are time periods when charges can be filed. But if it's a day later or 2 days later even, there's nothing barring a parent from doing that. It's just going to depend on what evidence is still around at that point. Yes, ma'am.
What sort of education are you going to have for the police department in terms of what sort of parameters, how they can go about charging somebody with this? The whole language of knowingly, I mean, if a police officer comes and there's kids drinking in the backyard, they're like, I didn't know. Is that enough to say what? They didn't know? So I guess my question is, what sort of education? Because that's sort of what I'm hearing from
Sure.
police.
Sure.
Issue with
Yep. So my office is, is taking on the burden of speaking to the police departments. It's something that we're really just starting to do because the law was just passed a few weeks ago. But we are going to be certainly in contact with the different police departments in the county, to explain to them what the law is, what it says. And again, not to repeat myself, but I think we have, fine police departments in this county that on their own volition stay on top of things like this. So between that and the initiatives that we take, I think they'll be well equipped to know, what the law is about. Now, to answer the second part of your question, as far as, they show up to the house and the person says, I didn't know about it. That's going to really come down to the police officer's discretion. I mean, they have discretion to charge or not to charge based upon their investigation. So if they feel that the person perhaps really didn't know, then maybe it's not appropriate to charge. If they feel that the person is just saying that because now the police are there, then they might, decide to charge at that point. So that's really, that's the discretion that the police have and should have, because everything is, different, different situation. But yeah, they would have that ability, despite what the person says, to charge if it's appropriate to do so. So, thank you. Yes, ma'am.
There's no way that a parent would say, yes, I knew about this.
Maybe not. I mean, you'd be surprised. I can tell you, I've heard, people that were charged with things admit more than I would have ever thought that they would. But it's likely, you're probably right, that they may not, especially when they know that they can get in trouble for it, may not admit to it. Thankfully, we don't need them to admit to it in order to be able to charge them with it. The police will do their full investigation, and if they have 3, 4, 5, 6 children that are all saying the same thing, that, Mrs. Smith gave me the alcohol, or Mrs. Smith sat on the couch while I drank the alcohol in her living room. Remember, the children are not the ones being charged with anything under this. So that could potentially be enough to have the, the adult charged based upon what the police investigation reveals. So, but that's a good question. Any other questions? No? All right, well, I don't really have much more to say about it than that. We're excited that the social host law is now here in Orange County. I think there really are, no downsides to it at all. I think it'll be great. And, hopefully the aim of the statute is to keep our underage children safe from alcohol. And I think this is definitely a good tool in that toolbox. Yes, sir.
I have one question.
Sure.
One was, what's the third offense?
So a third offense, it's not enumerated in the statute, which typically means if there's no specific special treatment named for it, that it would be treated as the same thing as a second offense. So, I mean, that's something that I guess perhaps could be litigated at some point down the line. But at this point, my guess would be anything after a first offense would always be treated as the misdemeanor, as a second offense would be.
Second question.
Yeah.
I know laws, some of my questions, laws act as both a deterrent and a punishment.
Sure.
And the first offense being $500
Mhm.
violation.
Yep.
Is that really I know there's negotiations that happen behind the scenes.
Right.
Is that really a deterrent?
I don't know, to be honest with you. I mean, I guess once the statute is in place and it's used, maybe we can collect data at that point and see. But like I said before, I think the fine is important because it will help to fund programs that could actually go right back to the social host law. But I think the more important part of the first time conviction is that educational component. And I think that'll really be the more meaningful and the more exemplary part of the statute, because then we can collect data to see if these programs we're offering are actually, making a difference as far as recidivism goes. So I don't know. I mean, it's a good question. We won't know until we get some data on it, I suppose. So, but thank you. Yes, sir.
I think as part of the legislature's discussion, that was brought up quite a bit. And what you were saying, the educational component was a big part of this, and I think they've appropriated some $20,000
Okay.
to use for the education, your role and whatever else they come up with. But it's making people aware of the problem,
Right.
making people aware of their responsibility. And,
Absolutely.
the tragedy that happened in New Year's Day.
Yes.
And what the consequences can be. So that was a lot of what they said. I'm glad it was changed. There's one thing that Middletown Cares as a group asked that originally it was proposed over 18.
Okay.
This group asked that it be 18 and older.
Right.
I thought 18 was old enough to be responsible and be held responsible.
Sure.
But also glad that it was changed to be a violation for a first offense, because I think you'll get a lot less reluctance to charge someone and to try and prove it if the consequences are a violation. And like you said, the awareness and the educational impact of a violation, and then you are put on notice. If there's a second offense, it will be a misdemeanor, it
Right.
will be a crime, and you can go to jail.
Sure.
And it may play a role in civil liability if there is an accident. This was originally introduced by District Attorney Hoogler as part of his Stop DWI campaign initiative
Right.
in 2014.
Right.
So, hopefully, it will help to reduce or at least give people pause to think about if they're in the situation and they're drinking and going to go out and drive, that you're responsible and that this makes you more aware of what the consequences might be.
Right.
That was an important role with the legislature.
Yeah, thank you for your comments. I really couldn't have said it any better than that. And I should actually mention that the fact that Middletown Cares actually cared about this statute and cared enough to give input and suggestions certainly was not something that went unnoticed by both my office and by the legislature. I can tell you that you're actually one of the few coalitions in the county that, that gave suggestions and gave input into the statute. So, I mean, I think you really all deserve some of the credit as well for how the statute turned out in the end. And, I thank you for that, for caring enough to give some suggestions about it. So.
And in that vein,
Yeah.
I think kudos and credits should also go to our former coordinator. Thank him
Okay.
for pushing for this.
Okay. Yeah, I don't believe I had the privilege of meeting her, but certainly I trust you. If you feel that she deserves some kudos, we'll give them to her. So, yes, ma'am.
I have a question. You mentioned that anybody who's hosting has to be like 18 and up, right?
Yes.
And you also mentioned that in underage, somebody who's 21 and under, right?
Under the age of 21.
Yes. So when somebody 18 and up, 18 years old, right?
Mhm.
Was and there's alcohol and everything else. So who do you arrest if they are also in underage?
Would the underage drinker be arrested?
Yeah, if the person was also hosting is also 18 years
Okay.
old. They're also underage.
Not under this statute. They couldn't be. This statute deals only with the server, if you want to call it that, with the person that's either giving the alcohol or allowing the alcohol to be consumed. So the child that's under 21 that is actually consuming the alcohol could not be charged under the statute.
So even though the server is also 18 years old?
Mhm.
Okay, so you blame the parents?
It's not that we're blaming the parents, but the statute is made to hold accountable the person that is providing alcohol to an underage drinker. So this statute doesn't deal with the person actually drinking the alcohol, which doesn't mean that there aren't other statutes and laws that would deal with the actual person drinking. But this particular statute does not. This is for the server of the alcohol. Okay? Yes, ma'am.
So reasonable corrective action, you give a few examples.
Mhm.
You say, but not limited
Right.
to. So she opened the door. So as a parent, if I find this out and I tell the kid, you know what, you gotta go. I don't want this going on in my house.
Right.
And you leave and they get in the car and they have an accident. So where does the responsibility of that adult begin and end?
So under
In
this
terms of this corrective action?
Right. So under this statute, what the adult is charged with is, as first step to basically demand that the person stop drinking the alcohol, turn it over to them, or take any other reasonable action at that point. If, in the adult's opinion, the reasonable step at that point is essentially to kick the child out and say, get out of here, you got to go home, and something were to happen as that person was going home, there could potentially be civil liability for the parent. I don't know. It would depend on, if the person knew that they were going to drive home, probably not a great idea to be able to do that. If the person knew that they didn't have a car at that home and they'd be walking home, maybe less liability. I mean, it's really going to depend on what happens. Personally, I think the best course of action, especially after the first step is taken, where the child is either unwilling to relinquish the alcohol or agrees to relinquish it but then continues to drink, would be to call that person's parent or guardian or the police, if you can't get in touch with that person, to have them come in and handle the situation, which would, resolve you of any liability for what may happen after the child leaves. So, yes, sir.
Just to clarify that a little bit further, that was part of the debate and the discussion in the Orange County Legislature. The law originally said that one of the things you were charged with having to do was to ask a person to leave
Okay.
and to driving home, you then become liable.
Right.
So they took that requirement out of the law. You just have to ask them to stop drinking.
Right.
And make sure that that doesn't continue. And then how they get home is a separate question from this law.
Right.
This law.
I agree. And I think kind of just, to hypothetically think of situations, if the parent, demands that the child either give them the alcohol or stop drinking it, and they don't comply with either of those two things, perhaps something else reasonable that they could do short of sending the child out and, out of their home while possibly drunk would be, to take the alcohol, to either put it somewhere where they can't get it, to dump it down the drain. I mean, there are a number of things, and I think that's why the statute didn't give a definitive list and say you have to do this and then this and then this. It's basically giving some suggestions in an effort to explain what reasonable steps are, but it's not limited to just the things there in the statute. It's anything that the parent feels or the adult feels is reasonable to prevent or to stop the underage drinking. So, I mean, it's going to come down to, again, to say it, the facts and circumstances of the case. If they're out at a picnic, let's say, and they're leaving the pavilion area and drinking away, then perhaps the answer to that is to have the adult that's in charge of that party, be stationed where the alcohol is, so they can't take it and go. I mean, those are just examples. It's going to all depend, but whatever is reasonable would be what the parent is charged with doing. So, yes, sir.
I know we're using the term parent, but I noticed you use server also.
Yes.
So it can be just an adult, somebody who's 21 and over.
Yes.
Having a party and serving underage.
Yeah, and actually, I shouldn't be saying parent. I say parent because that's the more traditional, case that we see. But it doesn't have to be a parent. It's anyone that is 18 or older that has control over the area and is allowing this consumption. So it can be, a junior in high school and his, first-year college buddy who's 19, 20 years old. That fits under the statute just the same as a parent would. So there doesn't need to be any kind of, familial relationship, any kind of blood relationship. And I guess I am wrong for saying parent. I really shouldn't say parent. It's any person that's 18 or older that allows this consumption.
Like providing it or just allowing it?
Either.
Because under when she was saying the person is 18 but not quite 21 yet and hosting the party.
Right.
And under the statute, they have to be 21 and over for you to charge them.
No. 18.
18 and over.
No,
So,
yeah.
so that 18-year-old will get charged.
They could be charged, yes. Yeah, it seems that they would fall under the statute as someone that was violating the social host law. Yes, absolutely. Yep.
And also, what kind of steps do officers take to maybe shut down a party to figure out who the host, person is?
I mean, I can't really answer that question. It's going to depend on the officer and the situation, but I can tell you what they would do, as they would on any case when they're called to, is, they'll do an investigation, make sure, obviously, first and foremost, everyone is safe, no one's in any immediate danger, and then they're going to do their full investigation like they would for any other matter. So, I mean, I can't give you specific steps that they would take. I don't know them, but they would do whatever's appropriate in the situation. Yes?
And I'm gonna go there because I'm thinking in terms of, more urban areas as opposed to, homes with, big lawns. And, you have folk in urban areas sitting out front, on a stoop. And it just seems more, possibly, there's a potential for police to pick up on that before they'll pick up on a more residential environment. And, I would just caution, back to the training piece of it, to include that cultural awareness piece.
Right.
Because, again,
Yeah. I mean, obviously, I completely respect what you're saying, and I don't think that you're wrong necessarily. I mean, the police officer that sees it is going to be able to do something more than the police officer that doesn't see it. So, I mean, I don't know that that's necessarily a race or creed or anything type of argument. It just is as it is. But I think you're right. I think the educational component is most certainly the most important part of this. If we never see anyone charged under the social host law, I don't think there'd be anyone that had a problem with that. I think everyone would be fine with that if it meant that everyone knew that they couldn't do this and they were, abiding by the law. But of course, if that doesn't happen, that's why we need this law in the books, that there is something we can do if we need to do it. So, but I agree. I
just think that it's more likely that the police, again, maybe, I won't even say more likely, the to roll up on, you know, a corner of black young males as opposed to rolling up on in Orange County Park and, you know.
Right.
and-
I don't disagree with you. I mean, of course, you know, there are what's called a certain expectation of privacy, where you have much more of an expectation of privacy in your home than you would out on the street. And, you know, that's the case with a statute like this. If you're going to be, I don't want to say brazen enough, because it may not be a malicious, you know, but if you're doing it out in the public, you know, unfortunately, you're going to have to deal with whatever consequences there might be for doing that. And I think that's no matter who you are and where you live. If, you know, I don't know that that matters, but I certainly understand where you're coming from.
Or maybe the local bar, where does the local bar get involved?
Well, I mean, the local bar, they could be charged under a different statute for serving an underage. Yeah, this is really not, yeah, this is more for someone that's not running an establishment. Although, perhaps if the situation is right, even this law could be used for someone in that case. But this is really not aimed at that. This is for social drinking rather than commercial drinking. So, actually, if I can, she had her hand up first. Yes, ma'am.
Hi. This is a little repetitive, but I just wanted to be clear.
Sure.
So if you have like an 18, 19-year-old has a party, they're drunk, but it's their house, they hosted the party, they can't be charged under this because they're drunk, or they can be charged?
Yeah, no, their intoxication doesn't preclude them from being charged, even though they're underage, yes.
Could be charged.
No,
So like if
you're saying if they're the one providing it or allowing it to happen?
18, they have a party, say they're like a senior in high school,
Right.
18, they have a party, there's kids from other grades
Mhm.
there, even though they're a minor and they're consuming alcohol, they can still be charged under this.
Assuming that they're giving it to someone other than themselves, you're saying?
They host a party, that's
Yes.
okay.
Yep, absolutely. I mean, that's essentially what the statute is.
Okay.
Yeah. Yep. Yep. Yes, sir.
Going along the same vein as she was saying.
Yeah.
It's sort of a prevention of the likely possibilities of that. Are we going to be or you or whoever going to be keeping statistics and data from the local?
Yes.
police department?
We already do on, you know, on any case that my office handles as a prosecutor, we keep records on, you know, the type of case and the outcome, obviously, who the person was. So all those records are already regularly kept. I don't see any reason why these cases would be any different.
So for instance, if a call is made to a residence, but there's no arrest, would that?
If there's no arrest, then my office never, we have nothing to do with it. We only get involved once an arrest has been made. So if,
The police officer is sent to a suburban place, but there's no arrest, there's no record, but they're sent to an urban place, and there's arrest, there is arrest.
well, there's no record in my office. If there's no arrest, then the district attorney's office has no record of it. That doesn't mean that the responding police department doesn't. And in fact, and Sergeant, I don't mean to put you on the spot, but I'm sure any call that the Middletown Police Department responds to, there's a blotter entry and a record of that call, no matter what the outcome is, correct?
Absolutely. Every call will be recorded, what was the call for and what was the outcome, brief description of what happened. So
Right.
it would absolutely be recorded.
So that'll continue. The police departments will continue to keep records. My office only gets involved once an arrest has been made.
Okay, one last follow-up.
Sure.
Because I was actually interested in that. So your office is going to be doing the prosecutions, or is it the localities, the townships, and everything?
No, my understanding is that it's my office that would be doing the prosecution of it. Certainly, at least the second offense, because that is a misdemeanor crime. My office obviously is charged with criminal prosecutions. But we also prosecute violations, things like disorderly conduct, harassment in the second degree. Those are penal law violations. They're not crimes, but my office handles them. So yeah, my suspicion rather is that we will handle all of these cases as well. Yes, ma'am.
Just a question as far as the adult, the 18-year-old, where does it fall? Because I know you keep on saying it's up to the police officer, but if, you do find out and you're sitting there and you're like, okay, you don't want them to walk off, you're not, so is there a provision where when you do call the police that, you're not going, like, if you didn't do anything wrong, that there's nothing wrong there, to make sure that, is there some kind of thing where it makes it easier and less of a feel like, okay, well, I know one of my top options are, I've walked in, this is going on, I'm not allowing it, I don't know these children or whoever this is.
Right.
And the reason that this did come about, you know, with all the different violence, I can pick up the phone, call the police, and know that I'm okay, that this is not going to actually,
Fall on you.
right.
Right. Well, remember, the statute requires that the person either knowingly allow or had reason to know that this was happening. So in a situation like you just described, where a parent walks in and this is already happening in their home, and they immediately, take some sort of corrective action, be it breaking up the party, calling the police, I can't imagine that they would ever be charged under a situation like that, because they have not violated the statute. They haven't knowingly allowed this to continue. So this is really for a parent that's there while it's happening and allows it to continue, or worse, facilitates it happening. But in the situation that you described, if they come into this situation and do what they should do, I can't imagine they would ever be charged under the statute. Yes, ma'am.
What about if there's a situation whereby a 17 years old throwing a party at a park? What would you do in that situation?
What would I do in that situation?
Yeah,
I can tell you it wouldn't fall under the social host law, because that person is not at least 18 years old. So that doesn't mean that there can't be corrective actions taken. The police could respond and break it up just like they could under any other situation. But they would not be allowed to be charged under the statute because they don't meet the minimum age requirement. You have to be at least 18 years old. Yes, sir.
I just wanted to say that I've been aware of social host laws and been following this for quite a while. And, Sullivan County's had it for a long time.
Right.
Ulster County, Dutchess. And in the last several years, I'd say going back maybe 4 or 5 years, I've only seen 3 or maybe 4 actual charges of violations of the social host law. I think 2 in Sullivan County.
Okay.
1 in Ulster. So it doesn't happen a lot. One happened when there was a call because there was a disturbance, which was what would have happened out in Pine Bush.
Right.
Check on the disturbance. The others were, I think, when someone had gone in a ditch looking for a place to park, going to the party, but it has not been used a lot, but it is there as an awareness that it can be used.
Right.
And particularly in this egregious situation.
Sure.
There also gets to be some confusion because the law defines a minor as under 21, but that's for drinking.
Right.
That's for
Consumption of alcohol. Right.
Is under 21.
Right.
New York state law, a minor is someone under the age of 18.
Right.
18 is the age of majority. But that person could still be charged as a juvenile because they're under 19. So I don't,
Right.
I don't know that would make any difference.
Right.
For a first offense, it might for a second offense.
Yeah, in order for someone to be charged as a juvenile offender rather than to go into the mainstream criminal justice system, they have to be committing a crime. And because the first offense of this would not be a crime, they could not be charged in family court with violating the statute. So, but if I can just piggyback on what you said real quickly, I think you're absolutely right. I think the statute really is intended to be there if we need it, almost as a safety net, but really to encourage and to facilitate awareness and training about this issue more than seeing parents getting, charged and convicted of it. If that needs to happen, that'll happen. I mean, that's what I do. But really, that's not the goal of the statute, is not to get parents, to trap them, or it's to educate them that this can't happen and that there would be consequences if it was violated. So I appreciate your comments. Any other questions? All right. Well, again, thank you very much for allowing me to speak to you this evening. I hope I've been able to shed at least some light on the social host law. And if you have any questions, after you've had some time to digest it. And I should mention, actually, there are copies of the law up here on the table. If you haven't grabbed one already, please feel free to do so on your way out. And then if you have any questions for me, you can either get in touch with me directly or in touch with Kelly Ocasio, and she can forward your questions to me. So, again, thank you very much, and hope you have a nice night.